15th of August, Nicky da Costa, Director of Legislative Affairs at Number 10, sent a memorandum to the Prime Minister, copied to 7 people, civil servants and special advisers, recommending that his parliamentary private secretary approach the palace with a request for prorogation to begin within 9th to 12th September and for a Queen's speech on 14th October. The Prime Minister ticked yes to that recommendation. On 27th or 28th August, in a telephone call, he formally advised Her Majesty to prorogue Parliament between those dates. On 28th August, Mr. Jacob Rees-Mogg, Leader of the House of Commons and Lord President of the Privy Council, Mr. Mark Harper, Chief Whip, and the Baroness Evans of Bowes Park, Leader of the House of Lords, attended a meeting of the Privy Council held by the Queen at Balmoral Castle. An order in Council was made that Parliament be prorogued between those dates, and that the Lord Chancellor prepare and issue a commission for proroguing Parliament accordingly. A cabinet meeting was held by conference call shortly after that in order to bring the rest of the cabinet, quote, up to speed, end quote, on the decisions that had been taken. That same day, the decision was made public, and the Prime Minister sent a letter to all members of Parliament explaining it. As soon as the decision was announced, Mrs. Miller began the English proceedings challenging its lawfulness. Parliament returned from the summer recess on the 3rd of September. The House of Commons voted to decide for themselves what business they would transact. The next day, what became the European Union Withdrawal No. 2 Act passed all its stages in the Commons. It passed all its stages in the House of Lords on the 6th September and received royal assent on the 9th September. The object of that act is to prevent the United Kingdom leaving the European Union without a withdrawal agreement on the 31st of October. On the 11th of September, the High Court of England and Wales delivered judgment dismissing Mrs. Miller's claim on the ground that the issue was not justiciable in a court of law. That same day, the Inner House of the Court of Session in Scotland announced its decision that the issue was justiciable, that it was motivated by the improper purpose of stymieing parliamentary scrutiny of the government, and that it and any prorogation which followed it were unlawful and thus void and of no effect. Mrs. Miller's appeal against the English decision and the Advocate General's appeal against the Scottish decision were heard by this court from 17th to 19th September. Because of the importance of the case, we convened a panel of 11 justices, the maximum number of serving justices who are permitted to sit. This judgment is the unanimous judgment of all 11 justices. The first question is whether the lawfulness of the Prime Minister's advice to Her Majesty is justiciable. This court holds that it is. The courts have exercised a supervisory jurisdiction over the lawfulness of acts of the government for centuries. As long ago as 1611, the court held that, quote, the king, who was then the government, hath no prerogative but that which the law of the land allows him, end quote. However, in considering prerogative powers, it is necessary to distinguish between 2 different questions. The first is whether a prerogative power exists, and if so, its extent. The second is whether the exercise of that power within its limits is open to legal challenge. This second question may depend upon what the power is all about. Some powers are not amenable to judicial review, while others are. However, there is no doubt that the courts have jurisdiction to decide upon the extent and limits of a prerogative power. All the parties to this case accept that. This court has concluded that this case is about the limits of the power to advise Her Majesty to prorogue Parliament. The second question, therefore, is what are the limits to that power? Two fundamental principles of our Constitution are relevant to deciding that question. The first is parliamentary sovereignty, that Parliament can make laws which everyone must obey. This will be undermined if the executive could, through the use of the prerogative, prevent Parliament from exercising its powers to make law for as long as it, the executive, pleased. The second fundamental principle is parliamentary accountability. In the words of Lord Bingham, senior law lord, quote, "The conduct of government by a Prime Minister and Cabinet, collectively responsible and accountable to Parliament, lies at the heart of Westminster democracy," end quote. The power to prorogue is limited by the constitutional principles with which it would otherwise conflict. For present purposes, the relevant limit on the power to prorogue is this: that a decision to prorogue or advise the monarch to prorogue will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive. In judging any justification which might be put forward, the court must, of course, be sensitive to the responsibilities and experience of the Prime Minister and proceed with appropriate caution. If the prorogation does have that effect, without reasonable justification, there is no need for the court to consider whether the Prime Minister's motive or purpose was unlawful. The third question, therefore, is whether this prorogation did have the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. This was not a normal prorogation in the run-up to a Queen's speech. It prevented Parliament from carrying out its constitutional role for 5 out of the possible 8 weeks between the end of the summer recess and exit day on the 31st of October. Proroguing Parliament is quite different from Parliament going into recess. While Parliament is prorogued, neither House can meet, debate, or pass legislation. Neither House can debate government policy, nor may members ask written or oral questions of ministers or meet and take evidence in committees. In general, bills which have not yet completed all their stages are lost and will have to start again from scratch after the Queen's speech. During a recess, on the other hand, the House does not sit, but parliamentary business can otherwise continue as usual. This prolonged suspension of parliamentary democracy took place in quite exceptional circumstances. The fundamental change which was due to take place in the Constitution of the United Kingdom on the 31st of October. Parliament, and in particular the House of Commons, as the elected representatives of the people, has a right to a voice in how that change comes about. The effect on the fundamentals of our democracy was extreme. No justification for taking action with such an extreme effect has been put before the court. The only evidence of why it was taken is the memorandum from Nicky da Costa of 15th August. This explains why holding the Queen's speech to open a new session of Parliament on the 14th of October would be desirable. It does not explain why it was necessary to bring parliamentary business to a halt for 5 weeks before that, when the normal period necessary to prepare for a Queen's speech is 4 to 6 days. It does not discuss the difference between prorogation and recess. It does not discuss the impact of prorogation on the special procedures for scrutinising the delegated legislation necessary to achieve an orderly withdrawal from the European Union, with or without a withdrawal agreement, on the 31st of October. It does not discuss what parliamentary time would be needed to secure parliamentary approval for any new withdrawal agreement as required by Section 13 of the European Union Withdrawal Act 2018. The Court is bound to conclude, therefore, that the decision to advise Her Majesty to prorogue Parliament was unlawful because it had the effect of frustrating or preventing the ability of Parliament to carry out its constitutional functions without reasonable justification. The next and final question, therefore, is what the legal effect of that finding is, and therefore what remedies the Court should grant. The Court can certainly declare that the advice was unlawful. The Inner House went further and declared that any prorogation resulting from it was null and of no effect. The government argues that the Inner House could not do that because the prorogation was a, quote, proceeding in Parliament, end quote, which, under the Bill of Rights of 1688, cannot be impugned or questioned in any court. But it is quite clear that the prorogation is not a proceeding in Parliament. It takes place in the House of Lords chamber, in the presence of members of both houses, but it is not their decision. It is something which has been imposed upon them from outside. It is not something on which members can speak or vote. It is not the core or essential business of Parliament which the Bill of Rights protects. Quite the reverse. It brings that core or essential business to an end. This Court has already concluded that the Prime Minister's advice to Her Majesty was unlawful, void, and of no effect. This means that the order in Council to which it led was also unlawful, void, and of no effect, and should be quashed. This means that when the Royal Commissioners walked into the House of Lords, it was as if they had walked in with a blank sheet of paper. The prorogation was also void and of no effect. Parliament has not been prorogued. This is the unanimous judgment of all 11 justices. It is for Parliament, and in particular the Speaker and the Lord Speaker, to decide what to do next. Unless there is some parliamentary rule of which we are unaware, they can take immediate steps to enable each House to meet as soon as possible. It is not clear to us that any step is needed from the Prime Minister, but if it is, the Court is pleased that his counsel have told the Court that he will take all necessary steps to comply with the terms of any declaration made by this Court. It follows that the Advocate General's appeal in the case of Cherry is dismissed and Mrs. Miller's appeal is allowed. The same declarations and orders should be made in each case. Copies of our full judgment explaining these conclusions and a transcript of this summary will be available immediately after the Court rises, and I urge you all to read them with care. The Court will now adjourn.